Thank you, Henry. I'd like to first off try and enter into this competition to be the voice of Middle America. I think that I think I can whomp Lou and Robert. All right. Now, what I'm afraid of is this guy who's sitting to the left of me, and I'll let him decide if he wants to get into it. But I want to tell you that I spent 20 years in Iowa, teaching there at the University of Iowa, before I made a retreat to better weather in North Carolina, where I live now. And that right now I am spending the semester back at the University of Iowa teaching there. So I think my credentials as the voice of the Midwest far surpass, put Lewis and Robert together, and I've got them beat. The title of this panel, or at least the subtitle of this panel, is What the Third Restatement of Torts Means to You. And let me tell you what the Third Restatement meant to most of you. My sense is that most of you are trial judges. Let me tell you what it meant to, we'll leave him anonymous, trial judge from Iowa in Madison County. What it meant to him was getting reversed by the Iowa Supreme Court. That's what it meant to him. The case that I have included in the materials, and it's actually at the back of the asbestos panel materials, and it's the last 12 pages of that, is a case, Thompson against Kaczynski, that was decided just a couple of weeks ago by the Iowa Supreme Court. It was a run-of-the-mill torts case, involved a trampoline that had blown out of the yard of the defendants, and the plaintiff had been injured in an accident on the road where the trampoline ended up. The trial judge dismissed the case on what looked to be pretty good grounds under Iowa law, and then found out from the Iowa Supreme Court, and there was really no way for him to know this at the time, that the Iowa Supreme Court decided to adopt the Third Restatement of Torts with regard to some central principles of tort law, negligence law, that is duty and the role of foreseeability and actually beyond that. So that's what it might mean to a trial judge. It means your reversal rate may go up. That shouldn't make it very popular. If you're an appellate judge, I think what the Third Restatement of Torts provides is an opportunity to consider what the American Law Institute has to say about an area and whether that is a coherent view of law and whether it might improve, or maybe it's consistent with, in many cases, state law today is consistent at least with the Second Restatement of Torts, if not the Third Restatement. Let me tell you a little bit about the Third Restatement of Torts, how it gets done, and what is yet to come. As Henry adverted to, the Third Restatement of Torts is not being done the way the first or the second were, where there was one reporter who did everything. There was no William Prosser on the scene when the Institute decided in the early 90s that it was time to update the Second Restatement of Torts. And so the Third Restatement of Torts has up to now proceeded in different projects. Specific pieces of torts have been identified, and then a project has gone forward in that regard. The first piece was, of course, products liability. That was completed in 1998. It's out, it's published, it's been around for 10 years, it's been around for a decade. Courts have confronted it. A number have found it helpful. Some have not. A few have not. The second project was about apportionment of liability. That dealt with comparative fault, joint and several liability. The Second Restatement had a provision that said plaintiff's negligence bars recovery. Well, that wasn't really of very much help by the late 90s. And so the apportionment of liability project was undertaken in the mid-90s and completed in 2000 and is out. A somewhat larger project was begun in the late 90s, and it's gone through a lot of different name changes. Its current title is Liability for Physical and Emotional Harm. Most of that project was completed in 2005, but not published because we went on and did some more. We did emotional harm, and we did landowner liability and added to the 2005 project. The first volume of physical and emotional harm, I'm pleased to announce, is being published today. West Publishing Company is issuing the first volume, which covers part of it. I'll explain that later. The second volume will be several years off for reasons that I'll also explain. There will be future third restatements of torts because these three projects do not cover the entire subject matter of torts. There's damages still to go. There are torts to real property, nuisance and trespass, that remain to be done. And there are some other areas that are yet to come. And there's a woman at Southern Methodist University, Ellen Pryor, who is going to superintend the process of getting those additional projects to complete what will be a integrated third restatement of torts done, but I'm not sure that will happen in my lifetime. Let me also just advert to the process of producing a restatement, what goes into a restatement. As you probably know, the American Law Institute began in the 20s. It was conceived of by some judges and academics and lawyers as an effort to, given the diversity of common law that existed in this country, to try and bring some consistency and coherency to the various strains of law that were developing in different states. That was the idea behind it, and that still remains its motivating force for what's trying to be accomplished. American Law Institute consists of about 3,000 lawyers, judges, and academics. A project is identified by an executive council to be done. Reporters, who are almost always academics, are identified to do that process. And then an advisory committee is formed of judges, lawyers, and academics. Victor Schwartz has served as an advisor on several of the torts projects. Marshall also has served as an advisor on several of those projects. In addition to an advisory committee of experts, there is a group of interested members of the Institute called a Members Consultative Group that is also constituted and is involved in the process. The final step for any restatement, every restatement provision has to be approved by the entire, well, at a general membership meeting that occurs in May. Every restatement goes through an approval, a final approval, before the membership. Drafts are prepared and commented on by the advisory committee, by the executive council, by the members consultative group, and by many others who are interested. I can tell you, I've got the emails and the letters to prove it. Revisions are made. A draft may go back more than once to those committees and to the annual meeting membership before it is finally approved. So if there's one thing, it seems to me, that the Institute does well, it is its process in which judges say to academics like me, Mike, you have to make this understandable. I need to explain this to a jury. And then the academics who are experts in the area weighing in as well. What I'd like to tell you about during the remainder of the time I have, Henry just cut me off when my time is up.
She'll let you know down there.
Is what is in this latest restatement, the one that Volume 1 is being published today and Volume 2 is several years off. And let me add that all of this restatement is available on Westlaw and Lexis. Hard copies are available from the American Law Institute in Philadelphia, not in final published versions, but in tentative drafts that have been approved. And let me also say, if you're looking for something or you want something related to this third restatement, call me, send me an email. All my information is in there. If your jurisdiction is involved in revising jury instructions and you want to see if the third restatement could support jury instructions that you're trying to revise, give me a call, write me. I'm happy to try and help in any way that I can with regard to the availability and use of the third restatement. I think the only materials under your restatement third tab in the materials is a table of contents of summary of contents and a table of contents of what's contained in this physical and emotional harm restatement. The table of contents that you have is from the page proofs of the volume that is being published today. So what's in this restatement that might be of interest? Well, one thing that's in there is to attempt a clear explanation of the role of duty in tort law. And we were talking about cutting-edge issues in asbestos. One of the cutting-edge issues in asbestos litigation today that a number of state Supreme Courts have confronted, some not yet, is whether a duty is owed by an asbestos defendant to the spouse of a worker who was exposed to asbestos and brought it home on his or her clothes, and then that dust, a member of the family, spouse or children, were exposed to that dust, and very often these are mesothelioma cases, the worst disease that asbestos causes, because mesothelioma requires less, the threshold for mesothelioma is less than the other asbestos diseases. So the question is there a duty by a building owner or the employer of an independent contractor or by an asbestos product manufacturer to these family members who weren't at the job site, weren't in the building? This is an issue that some of those courts, I think most of those courts, have found the third restatement on physical and emotional harm and its treatment of the question of duty and when a duty exists, and the difference between an ordinary duty of care and when there's a special duty, an exception to the proposition that ordinarily there is no duty to rescue, no duty to protect someone from dangers that another is exposed to without the contribution of the defendant. So this would be, for example, the most famous instance of it is the duty of psychotherapists when a patient is dangerous to a third party. And in the California Supreme Court back in the 60s decided that psychotherapists do have such a duty to third parties. This is a duty to protect, not part of the ordinary duty when you create a risk to another to take reasonable care. Courts have been relying on the third restatement, duty provisions in that regard. There's also in the third restatement, and this part of the restatement, candidly, is not consistent with practice in many jurisdictions. The third restatement suggests that foreseeability should not be a part of duty analysis, but rather is only relevant to whether there's a breach of duty, that is, whether there's negligence. Both the Iowa Supreme Court 2 weeks ago and the Arizona Supreme Court, confronted with those questions in the third restatement, decided that the third restatement was persuasive in that regard and removed foreseeability from their consideration of duty. There are changes in legal causation in the Third Restatement from what you would find in the Second Restatement. One of the important things is to separate out the idea of factual cause from the more normative determination of how far will liability extend. The Third Restatement attempts to do away with the term proximate cause, which is used in a variety of different ways and confuses judges, confuses lawyers, and it confuses juries. And to separate out the two different things that are going on, factual cause and limiting liability, and using terms that are better descriptive of what's going on. I should also say that the substantial factor idea that was so much in discussion at the asbestos panel has been eliminated because of the confusion that it generates in an attempt to get straight to the core of the matter. Was the contribution of the defendant so insignificant that there ought not be liability here is the explanation, as I adverted to this morning, is the way in which the Third Restatement deals with causation. Other subjects that are in there, and I'm just going to sweep very quickly, is with regard to the instances where these affirmative duties, and by that I mean a duty to protect or to rescue exceptions to the ordinary obligation, to the ordinary rule, which is you don't have to rescue and you don't have to protect, are addressed in there. Reform of landowner duties. Once again, I'll advert to the Iowa Supreme Court, which just this past summer decided to get on the modern trend and to impose a duty of reasonable care aside from the traditional categories, status-based categories of trespasser, licensee, and invitee. The Supreme Court became, I think, the 26th or 27th state to say, let's just use a duty of reasonable care, at least with regard to invitees and licensees. We have had an expansion of recovery for standalone emotional distress since the Second Restatement. The Second Restatement had no recovery for negligently inflicted emotional distress. The Third Restatement attempts to take that subject on, to categorize it and to tame it, and to identify the limits that exist for recovery of emotional distress. There's more in there, lots more goodies. The thing that I will end on is a prediction that, having just been published, keep your eye on the New York Times bestseller list to see when the Third Restatement makes it there. Thank you.